Okay, I think we'll get started. Um, Again, Tricia Bach, HRD Administrator. We also have Liz Gagan. She is the senior. Oh, you introduce yourself then.
I work at the Attorney General's office, and I work doing the employment law questions. So I know a lot of you. I don't know all of you, though. So that's what I do.
And I'm Erin Williams, Agency Services Human Resource Division.
All right, we did have a question from yesterday that we're going to address. I have feedback again. So we'll address that, but first we wanted to talk a little bit about the exempt, non-exempt generally. I'm going to turn that over to Erin.
We had a question from yesterday, and the gist of it is I don't have the paper with me, but who is the final determination on who makes the decision for an exempt, non-exempt? The 19 years that I've worked here, it's gone back and forth depending on who's in the DOL position, who's making the interpretation from the AG's office, and who's working as the HRD administrator. We are currently under the ruling that HRD is the entity who should make the final determination on exempt, non-exempt. The reason we wanted to show this presentation today is we don't just handle that with us reviewing them and making a determination separate from the agency. We like to approach it as a collaborative approach. You guys know the positions better than we do. It's really hard to determine the level of authority in a position and some of those criteria on the tests just with a JCQ. And so we'll usually sit down in occupational study meetings, reclassification meetings, and discuss those together and go through the tests. And we'll see if we arrive at the same decision, and if we come up with the same decision, we move forward. If there are disagreements, we'll pursue it a little further. The contact that we have at World at Work, who you listened to today, we can email them and ask them the questions. We also have a DOL contact that we work with pretty regularly who's down in Colorado. And so we do have some resources available to us that if we are in disagreement or unsure, that we can reach out to, and then ultimately HRD will make that final decision.
So one nice takeaway from that is, as dry as that was for the last hour and a half, at least you know you don't have to make that decision on your own. We can work together and make that decision. So if you didn't pay complete attention to everything the gentleman said, we're here to help as well. So you don't have to worry about making that decision and making the wrong decision, because we'll work with you on it. Hopefully that answers the question on the exempt, non-exempt. There was also another question, and since Liz is up here, I wanted to make sure we talk about it again, and it was the question on what avenues do HR representatives have when they're when they report directly to a director, and the director is either asking them to do something that they shouldn't be doing or something to that effect. And we talked about the fact that you can come down to HRD, you can bring it up with your personnel attorney, and I don't know if you want to bring anything else with that. It's a difficult situation. So it's happened in the past, like I said yesterday. So I think the best avenue is either down here, or I think the AG's office would be willing to talk to you about that as well.
We would certainly be willing to talk to you about that, but HRD is a good help as well. And it is a difficult situation.
It is. Surprisingly, there's not a ton of them, so that's a good thing. Other question that we had one other question in the box today. Oh, yes. Anne, do you want to repeat your question?
The question comes up about hostile work environment. You know, if somebody is working in a work group and the supervisor is being mean to them, they like to come to HR a lot and say, you know, this is a hostile work environment. And so could you please, you know, define what a hostile work environment, what that means?
Legally, a hostile work environment is a term of art, and it comes from Title VII type of law. And in order to have what I'll call a legally cognizable hostile work environment, the hostility has to be based upon someone's membership in a protected group. So it could be someone's gender, it could be somebody's religion, it could be a disability, any of those types of issues. General hostility or uncivility is not something that, that the law protects necessarily. Obviously, though, that type of behavior is not conducive to a very productive workplace. So it's still important, I believe, but it's not a legal issue unless it's based on a protected class. And even then, it has to be so severe and pervasive that it actually alters someone's working conditions. Of course, we don't want it to ever get anywhere near that. It's kind of our duty and thought that we need to try to fix those issues before they get anywhere near that. But that's another piece of it as well.
We have one final question that came in today, and the question is, has there been a discussion on going away from sick and annual leave and giving personal time off, PTO? Seems like it would reduce the amount of payout liability the state would have. And actually, over the course of the past couple of years, we have run in HRD numerous scenarios of what the cost is for the unfunded liability and what going to a PTO system would look like and how we could implement that. In our recommendations, the current employees would be grandfathered in with the current sick and annual leave that we have, and the PTO would start out with all new hires. We have routed that through our membership chain. I know it has made it in front of the legislature and up to the governor's office, but at this point, no official decision has been made moving in that direction.
And I do think that the Efficiency Commission, Alvarez and Marcel kind of indicated that that might be something as an efficiency you could do with the state too. So I assume that'll continually be an issue for PTO.
Hello again. Because you mentioned them, would you kind of briefly describe the efficiency studies that the Alvarez is going to be doing and what your anticipation, how long that'll be?
I know enough to be dangerous about what Alvarez has done. I don't know what the scope of work is going to be for the new consultant. I don't even know who the consultant is. I don't think they've picked him yet. So my understanding is that the new consultant that they went out, I think the first or the second Efficiency Commission meeting is in October. We'll probably know more about that when that happens. Alvarez and Marcel did an abbreviated study. They did a basically, here's the quick areas that you might have some cost savings. It was, there were recommendations that the Efficiency Commission didn't necessarily say, yes, we're going to do that. The governor, however, did send out a memo to the directors on 4 items that he would like basically A&I to look into. One of them is the span of control study. Most of you are aware, the bigger agencies are aware that we went through and HRD and the agency together collaborated on what may or may not be able to happen within each agency. We just finished a draft of that report about a half an hour ago. So that report should be to the Efficiency Committee sometime in October in the governor's office. That span of control study coupled with, I think there's a motor pool evaluation, a space utilization study. There's a 4th one I can't think of. The next phase is where a lot of the other larger initiatives probably will live, depending on what the governor, the next governor wants to look at and what the Efficiency Commission would like to look at. So I don't know. I know about as much as you do at this point because we don't even know if they've picked anybody yet. So, and my understanding is they haven't yet. It's not finalized. There's no contract. So I don't know if it's Alvarez or another. I think there were 4 that bid on it. So that's as much as I know. I've been living span of control, and I think we all have for the last couple weeks. So.
I don't know, is it? I want to go back to the exempt, non-exempt, and specifically to a question that was actually brought up in the webinar, and that's with the time deductions. The question that was posed in the webinar was, is there such a thing as partial day time deductions for exempt employees? And the answer that he gave was outside of FMLA, he doesn't see where that could ever happen. And that's in the handout as well. I can see where that can be interpreted as in contradiction to how we use annual and sick leave for state employees. And the argument could be made for a permanent state employee using that type of logic. There's no such thing as an exempt employee. So could you talk about how to use annual and sick leave appropriately for exempt employees?
I want to talk a little bit about that first, and then I'll let Aaron and Tricia follow up. I disagree with the presenter, and there is a part of the Fair Labor Standards Act and in the regulations as well that says that public service is different than private, and that DOL understands that because public employers have to be accountable to taxpayers, that type of a rule, it doesn't work in public service. And there is, in addition to that, there is case law, and it's part of the regulations as well, that talk about it's okay for employers to have their exempt employees use sick or annual leave, in increments of less than a day. So that's specific. Where you could get yourself into trouble is if you are actually deducting the money from someone's paycheck. That's where it's something that you want to be very careful about. And as you mentioned, the FMLA specifically allows that, but when you start to make the deductions is where you want to have a conversation with probably someone in the personnel section and HRD as well.
And to go along with that, I think the other, if you remember or followed with the SAO and the timesheets with exempt employees, I think that's the same understanding that they're working under when they're talking about using timesheets for exempt employees, actually having them put their hours on there. I think it's the public service aspect of it, why they say that they should be able to do that, and they want us to do that. So I think it's the same idea. Anything more?
On hand for the public service employees?
Well,
The law, you mean? From what Liz was talking about? Or the case law?
Yeah, it's just something to have in the office to kind of show to people. We have people come in periodically that don't think they should be exempt because of different reasonings. And so I think if we could just show that, because when they go out and look at this, they don't necessarily look at the public sector part, like what
Okay.
you were talking about. So if that could be something, if there's something that we could have that would be handy to use,
But
as a tool.
if they're asking, I don't want to be exempt, I think I'm non-exempt, that's kind of a different document that you would have to show them.
Well, it would be, but I think if we could put all of it together for the public employee, does that make sense?
It does. And I think that's something we probably could work on. Maybe if Cherie was here, we could get her to work on it too. Well, this is your chance. You got Liz sitting here. Any other questions? They just all want to leave. We have to fix the round table. Put it earlier in the day.
If you had a probation employee that had told their supervisor that they were taking a medication, but the supervisor doesn't see that there's no evidence that this person is impaired one way or another, but they are having some performance issues. My thought was that you would just base it on the performance issues because you don't have any reason to suspect the person is impaired other than they're taking a medication for something. But they don't show impairment of any kind whatsoever. At some point, do you have to do the ADA, or can you just simply base it on performance unless you see signs that they're coming to work impaired?
I would handle the performance issues. And then if the employee says, well, it's a medication that I'm taking that's causing the performance issues, then you would look into an ADA review of the situation. Sure.
That was a good question. I think I'll ask a question. Going back to hostile work environment, if you have an employee that comes up and says, I'm in a hostile work environment, my supervisor doesn't like me, she always singles me out, she's just not nice to me. And you go down the road and you ask questions trying to figure out if it's based on a protected class or not. And if it's not, are you, as HR, required to still do an investigation? That's a question that HRD gets a lot, and I always send them over to you. So, so that's the question that hopefully you might be able to shed some light on.
I don't think that you have to do an investigation if you've asked enough questions that you're convinced that the hostile work environment doesn't have anything to do with membership in a protected class. You know, you always want to be careful because if you're wrong, you could have a liability issue down the road. And then again, I mean, I think that if it's true that someone's being singled out and that there's no rhyme or reason to it or no good reason for it, you know, you're going to want to look into it anyway.
Do you guys get that quite a bit? Is that a question that you've come across? I seem to get that probably once a month at least, which seems like a lot to me. How about personnel files? When you guys are looking at recruitments and you have an employee that is with another agency that is applying for your position, we don't get a lot of requests for seeing the personnel file or the performance evaluation. And I'm wondering if you guys are utilizing that as much as maybe you should be. You have? Yeah. Are you guys aware that you can get the personnel file? Okay, I just want to make sure.
And some agencies may be doing that with a release, and then there wouldn't be the need to go to A&I.
Right.
But you can go there if you don't have a release.
I know that the occupational studies have been frozen for some time. You have mentioned the trades occupational study, that's going to be up on, on the 1st there. I do know there's so many others though, and I'm wondering if you have kind of a schedule that you're thinking about, or, I know HR was up on that.
HR was actually was pretty well done.
It was like done, and then we were frozen. But another issue that I have is with the attorney classification. One of our MOU agencies is with the public defender, and they're very different than the attorney generals. And so I'm just wondering if you have kind of a schedule, and if you do, once it's open for you, how are you going to proceed?
Go ahead, Erin.
We have presented an occupational studies white paper to our agency director that has, I believe, also gone to the governor's office, just kind of explaining what occupational studies are, why it's important to do them. We also, like Tricia said, we've just finished our draft report for the Efficiency Commission. We do address in there that some of the areas that they felt maybe we had gotten out of alignment with, possibly we could have incorporated in a span of control review with our occupational groups during occupational studies. So we have addressed the need to continue on with those studies as a result of that efficiency as well. We do have a schedule that we have put together. So the trades is the first one we would do in conjunction with finishing the human resources. Attorneys are close to the top of the list. And how we would like to do those with the recommendation we put forward is we should be looking at the occupational groups every 2 to 5 years. We should just go through and work all the occupational groups and families that we have, and then by the time we've all the way through them, we're cycling back and starting over. So we do have a white paper addressing that, and we're just waiting, you know, and I'm not sure now if that's gonna come this close to the end of this administration, but we're hoping with the next administration, we can get that back up to them and get those started again.
To follow up with that, I do know that some of the reclassifications that we've turned in, just because we know they're so far out of whack, and I know that there's an occupational study in that group. I understand you're denying those at this time, and so could you just maybe explain and communicate with us why that is?
Yeah, if we get a large number of reclassifications or even a singular reclassification that we know that the whole series is wrong and we need to create a new level or revamp the occupational group, we are denying those until the study, because we found doing onesie twosie reclassifications, then we're having recruitments go out for maybe those vacant positions, and it's causing confusion for the agencies. Why did I see this position go out as a 9? We have somebody doing the same type of work there an 8. It's just a snowball effect that then we'd have to end up looking at all of the positions across all of the agencies anyway. So rather than creating those large numbers of inequities in occupational families that cross agencies, unless we can fix them with minimal disruption to the rest of the state agencies using that class, we're putting them on hold until a study.
Okay, I have 2 questions since we brought up release of records or releases for records. So we get a lot of reference checks and from another state agency, and they send us their authorization to release information on an applicant. Can we accept that and give them whatever information they're asking for? Or do we have to require them to fill out Appendix B of the personnel records policy to answer questions about someone's employment with us for another organization? And then the second question I have is, can we accept electronic signatures for release of information, such as for mortgage requests and things like that?
Let me make sure I understand the question. So you have somebody calling in from Department of Audit, say, saying that, here, I have this release. They email you the release, and then they just want to talk to you about the personnel file.
No, like it might be coming from Colorado Department of Corrections, and they've applied for work there, and they're sending us the Colorado Department of Corrections release for records information, and then they have a list of questions that they want us to answer regarding that employee's performance with us, and then, you know, aside from the PREA questions that by federal law we have to answer, you know, can we accept that Colorado Department of Corrections release for information on employment information for their recruiting purposes, or do we require them to fill out Appendix B of our records policy before we release anything?
I would let Liz answer this question.
So long as the agency is, you know, comfortable that the release is valid, and, you know, and if it's coming from a, you know, reputable source. We get a lot of them from the federal government, reputable source. Colorado Department of Corrections, again, reputable source. I think it's fine to go ahead and release the records. I mean, obviously, I'd look at the signature and look at a signature in the file to make sure they, you know, look similar and that type of thing. But if you're, you know, fairly certain that the employee signed it, and certainly if it's been notarized, then it's shouldn't be a problem at all. As to answering the questionnaires, I don't suggest that agencies answer subjective questions. They are certainly welcome to look at whatever is in the file and draw their own conclusions from that information. But when it gets subjective, I think that it could be a problem for the agency.
I would 100% agree with that.
Then the other question I had was, can we accept electronic signatures?
Yes.
We're actually going to a different one, but we started, the contract section started accepting electronic signatures, or is starting. So we're getting into the wave of the future. Pardon me? We haven't done that yet. Okay, so no, we're not going into the future. We started talking about DocuSign, and then that got kind of put on the back burner because it wasn't a corporate membership, and there was all kinds of issues with that. So I'm not sure where we are with that, but that kind of goes with the discussion about the Google Doc going back and forth. And I do think there is an opening for that. It's just a matter of whether we can do that or not. The PM20, who I think lives on the AG's website, and I don't know whose document it is, but we all use it. So we're meeting on that in a couple weeks, I think, with the contracts section to change that up a little bit. And I'll talk with Kristen about electronic signatures there. The problem is that all agencies would have to have, like, it's not an app, but a program to have DocuSign or whatever. And I'm pretty sure DocuSign was trashed and now it's Adobe. I'm not quite sure. Another one I know enough to be dangerous about. So we'll have a little more information on the PM20 at least after we discuss some changes we'd like to do with the contract section there.
I have a
Jared?
question for Liz. Obviously, everybody here probably has a social media account of some sort. I'm just curious how the content that's posted on social media and whether or not that can be actionable, disciplinary in nature, and whatnot.
It's a difficult question, and I don't know that I'll have kind of a black and white answer, because it's going to depend on a lot of different circumstances. When I think about a circumstance where I thought that the social media content was actionable was in a situation where I believe the person posting on social media was retaliating against somebody who had complained about a workplace issue and did so in a very violent way. So there's that. Obviously people are allowed free speech, so free speech is always in there. But getting on social media and kind of, bagging on or being inappropriate to your coworkers can really be a problem for the workplace. So that's where it gets a little bit gray, but there are certainly going to be situations where I think it's going to be actionable. Just because it's out there on social media doesn't mean that, then you can walk into the workplace and everyone's going to be expected to treat each other professionally. So, and obviously, if someone were to put something on social media that is confidential or something that they learned through the course of their job and other people don't have access to that information, that could be a huge problem. That happens with law enforcement officers. I don't want to say a lot, but I think that's the most frequent time that particular issue comes up.
I have a little bit to add to that because we've had some actionable issues regarding social media. And typically where I find that is when employees take work issues and then they take it offline and start chatting back and forth through Facebook or Snapchat, and someone makes a copy of whatever that commentary is and then brings it back into work and says, so-and-so's, harassing me or doing whatever through Facebook, or now they're talking bad about me and everybody doesn't like me, or I don't want to be in a relationship with them anymore and they're trashing me through Facebook, and now, now it's a problem at work. So those types of things can happen, and just remember that if just because you take it off of your Facebook page doesn't mean somebody hasn't already taken a picture of those messages and shared them with your HR office. So that's all I would offer on that end.
And I think our office grievance and appeals, Russ could probably say too, between Tricia and Russ, I think we've only seen 2 of those in the last 3 years. The social media issues and discipline or investigation. I'm sure the AG's office has seen more because we don't always see the letters of expectation and things like that. But any discipline, I think there's been 2, and it was basically, I don't like this coworker, and back and forth, and fairly aggressive.
So I guess to the extent that the social media doesn't have anything to do with work, it's probably fine. The more it's related to work and the people that you work with, the better chance that it could be a problem.
And be careful with politics during work hours while you're sitting at your desk and posting things. You know, timestamps are on there. So if anybody really wanted to call you out on it, it's in the rule. So just be careful with that, especially right now. You don't talk loud enough, you have to wait for the microphone.
Yesterday, you mentioned a little bit about grievances. Could you just respond back again about some of the changes that you might be thinking are coming?
Oh, with the personnel rules?
The personnel rules with the levels of grievances and stuff?
Well, it's the grievance committee. That's the main issue in that section, that we're trying to do away with the grievance committee. And one of the reasons is it's a waste of time for both the employee and for the agency. If the agency wins, the employee goes further, takes it up to OAH, and vice versa. If the agency is going to lose, they're going to take it up too. It's not a final decision, and unless neither one of them appeals it, then it's a final decision. But so, for example, say you have somebody who was involuntarily reappointed and had a disciplinary suspension. So they go in and they've been in that position now for 3 months. They've had 3 months of pay that has been docked basically on the involuntary reappointment. They go through the grievances. They're in the grievance committee. The grievance committee decides you should give him his money back, but we're going to allow the disciplinary suspension. But you shouldn't have involuntarily reappointed them. And the agency says, no, we're going to OAH because this committee is wrong. They feel it's wrong, they go to OAH. They don't get the money back until they're done with OAH. So it's, in my eyes, and then when you look at how many grievances we have, grievance committees we have, to make that employee whole, say the agency loses again at OAH, they just wasted probably 2 more months going through the grievance committee of not getting their money back. You see what I mean? So it's a waste of time either way. There's other reasons. There's more reasons that the grievance committees sometimes are not helpful. As much as we want to say in the personnel rules, you can't be an advocate for one or the other. It always turns out somebody's an advocate for somebody. Next thing you know, we learn they're your uncle. Nobody knew that, even though we asked those questions. Sorry, Liz and me, but you get attorneys on the grievance committees, it's a nightmare.
It is.
And we had 2 attorneys and a layperson on the committee. One, it lasted forever because they had multiple extensions, which lawyers do. But then they wanted everything. They wanted all these documents. I kept denying everything that they wanted. And then because they weren't getting what they wanted, I do believe that the decision was flawed. I think they took it out on the agency because they weren't allowed to have every car that ever had a GPS with the state of Wyoming, every report that they ever had. So not only is it a difficult tracking, making sure the right decisions are made, I think it's a waste of time for everybody, including the people that serve on them. Whether that goes through or not, we tried, I think Dean tried it when he was HRD administrator, and WPEA fought against it. I have had multiple conversations with WPEA, and I don't think they're going to fight it this time. You never know. They can fight it. They have the right to fight it. She understands the issue just as I do. So we'll see what happens. If that doesn't happen, the alternative that we've put out there is that the grievance and appeals coordinator is somebody who is always on the committee. The agency picks somebody, the employee picks somebody, and the grievance administrator sits on that committee, which gives a little more consistency. So that's an option.
So it would have to go through the thing that the rules would go through, like the 90 days and all that.
Microphone.
The 90 days and all of that, it would have to go through all of that if you were to change the personnel rules?
Yes.
It would go through the 90-day hearing
Yeah.
and everything? Okay.
Has to do all that. We have multiple changes to, I believe, 4 chapters,
Okay.
including PMI. We talked about that
Right.
yesterday, and that's still with the AG's office. The rest are already vetted through the AG's office. So,
Okay.
yeah, there's 4 chapters. It's the donated sick leave. I can't even remember all of them now. It's been so long. So, I don't know, I can't think of it.
Thank you. Bereavement leave.
There was something else. Oh, bereavement leave, we are asking, one of the things we are asking is to go to a 5-day instead of 3. We've looked at surrounding states and we're pretty much the lowest. I think Facebook just gave 3 months, something like that, paid. We can't do that, but we are looking to go into 5 days.
Just a suggestion, instead of talking days, can you talk hours?
Oh, yes, I know.
Because we do so many alternative schedules that are not 8-hour days.
That's a good suggestion.
That
I'm
would be
glad you
really
brought it up.
helpful.
Yep. Jenny, Tammy has a question. Oh, comment.
I have a comment about bereavement. And maybe you would consider a time frame that they could use that bereavement leave in. So if someone passes away now and they're cremated, 8 months later they want to use their bereavement leave. There's no time frame in the rules.
Okay. Good to know. I had not thought about that.
I have a question about loss of a member of the family being 2-legged versus 4-legged, and whether the employee has to take sick leave or annual leave.
For a 4-legged member of the family? I don't think our rules contemplate that, so I would say it would be annual leave. I have not had that question.
Well, it's interesting, my husband and I fight about it because he can take whatever he wants, that being DOT, and I am required to take annual.
What do you mean
And
he can take
who's
whatever
to
he wants?
say, he can take sick or annual. And who's to say that that 4-legged person was not as close as the 2-legged?
And I'm not saying I disagree with you because I just had, my dog just passed away, well, it feels like just, it was a year ago. I took annual leave. I would assume it's annual leave in all the agencies. So if that was something that came up, I don't believe if the question came down from YDOT, using sick leave would be approved.
Maybe it's an individual supervisor then.
Right, it could be, yeah. But generally speaking, it would be annual leave. Not that I don't think it should be free, it should be bereavement leave, you know, as far as I'm concerned, but the way the personnel rules, I believe it's annual leave.
You know, I think you could have a situation where someone maybe became very depressed after the loss of the animal, and that would
That would be different.
that would count. You know, they probably are going to have to be seeing a counselor or some sort of professional to, I don't know, diagnose, but verify that the person is having some issues and they're trying to get better.
I would agree with that.
So
Doesn't mean it's something you can bring up too, to say that we should be able to use sick leave for four-legged pets as well. I can't hear you. Wait for the microphone.
I've heard employees ask for if they could use sick leave for vet appointments too.
Yeah.
That was my answer, no.
Yep, I would agree.
So back to the bereavement leave, and I totally understand about, 8 months later, you're taking it and they died a long time ago. But there's also that that they're not doing any kind of a ceremony or funeral or anything, for 8 months. The person dies in the middle of winter and the family can't get together. So that would be the only caveat, I think, to that. I don't know.
And I do think we would have to research that a little bit. I would like to see what other states do. A lot of times I look at the University of Wyoming, see what they're doing. So I think we would research it and take all that into consideration.
Maybe require documentation that shows the ceremony or whatever's not going to happen.
Right. And it happens all the time that the ceremony or it's not a service, it's just the family gets together, and maybe while the problem I can see running into is the family gets together, they go on vacation to Mexico to spread the ashes, and then they want to use the bereavement leave during that time. Maybe they should be able to. That's just where I could see the issue coming up. I hear someone.
Well, so with regard to that time and space, like I lived in Maine for a number of years. I'm right here.
Oh, there you are.
I lived in Maine for a number of years, and they can't bury anyone in the winter in Maine. Like burying season is April to September. So if you die in October, your funeral is not going to be until at least April. And, I know that I knew several people who worked within the state of Maine at that point, and they had different classifications of bereavement leave. Like there was an immediate use for like 2 days, and then there was an additional 3 days that I think they could take when the actual event occurred.
And that's what I would like to do, is to research what the other states do, and that sounds appropriate.
And it might be worth looking at some of those states that have those severe kind of weather conditions, because that's the norm.
Right.
This is for Stacy, because I got the email from you. Not with bereavement, but there was an email sent out asking about pets in the workplace policy, not bereavement, but just comfort animals or whatever. I know my agency doesn't have one of those, and we've had employees ask about it. So I was just wondering if anybody else has that, or what the state policy is, Liz or Tricia.
If you're talking about a service animal, there may be an ADA issue. So when employees are making requests for that type of thing, you should be talking to your attorney. But I am unaware of any general policy regarding pets in the workplace.
I don't know of any agency, and like you said, service animals are going to be allowed in the workplace, so you need to talk with your attorney, absolutely. Comfort animals, I think you still need to talk to your attorney, because that's such a weird area right now. And I don't know what the law is there, because there's no registration or any kind of paperwork you have for a service animal, and it gets weird.
The Department of Justice has put out some information about what is a service animal pursuant to Titles 2 and 3 of the ADA. We usually deal with Title 1 of the ADA, but some courts are looking to what the Department of Justice said in determining the employment issues. It specifically says it has to be a dog. It doesn't allow anything else. And then it talks about training that the dog has to have to be able to treat a condition that the employee may have. So there are some specifics to it, but as Tricia said, there's no registration really for it.
think it was your agency HR who had asked Stacy that particular question. So we did a mini survey to see what agencies were currently doing. But Stacy had also sent out a survey to all of our states that we are in a consortium with through the National Comp Association. And she has some survey information from that, but I don't think any states had pet in the workplace policies. I think they were really, for the most part, against that, unless, like Liz said, they were determined and vetted through a process that there were actually a service animal. But Stacy can elaborate on that a bit.
Yeah, you're correct. Everything that came back was service animal related. Military department has things about service animals, and then Oregon was actually the only other state that replied with information about that too. Other states had nothing, so.
We did a policy.
You got to remember Matt's recording, so we can't hear you if you don't use the microphone too.
Sorry, the Board of Pharmacy did a policy on service animals in pharmacies because of the potential for contamination, and that was actually backed up by the FDA, and they call it insanitary conditions. So there had to be a division between public area and area where you prep drugs. And the Department of Justice website is fabulous. It talks about questions you can ask and questions you can't ask and what task the service animal, performs. So it really helped back us up when we had to come up with a statewide policy.
So back to the policy where the question came from, is it more of, are you allowed to have your dog in the workplace if you bring them in for National Dog Day or something like that? Because those are some of the questions we get too. Is that what some of it was?
Yeah, we've had both, where it's just the National Dog Day thing or the comfort dog, but then we do have the request for the actual certified accommodation, or service animal. So it's just interesting to see what the private sector is doing now versus what we're doing.
Does anybody in here have any experience with allowing employees to bring their pet to work on a day?
Okay, so at the Wyoming Retirement Center, it's a skilled nursing facility, and we actually do have a pet policy for residents and staff. Because we want that home-like atmosphere, we have a process that they have to go through. They have to be interviewed. They have to fill out an application, the owner, not the pet. Fill out an application, breed of dog, all that kind of thing. And then the pet actually has to undergo a pet interview. So the pet is brought to like think the social worker, the administrator, I don't know, 2 or 3 people. It has to be, and this is all lined out in the policy. It has to be obedient. It can't be snap at people or bark, it has to be appropriate for the facility. The resident or the employee has to be able to clean up after the pet. The residents have to be able to pay for the vet bills, the health care of that kind of thing for the pet and the food. It can't go in certain parts of the facility with, food. It can't be in the dining room or food prep area whatsoever. It's a pretty, what I think it was a detailed policy. So I don't know if that's, we've had it for several years, so I don't know if that was, I doubt it was even ran past anybody at A&I, so I'm kind of, or the Attorney General's office, so I'm kind of going, okay, Matt, you might want to erase this part, but it's been really good for, obviously, for the residents of the home. They are not service animals specific at all. They are just pets.
It makes sense for the retirement center, and I think that's awesome.
Yeah, and of course, when employees bring their pets, that is just more therapy that the residents get as well, more exposure to those pets. But it is pretty specific, and the right can be revoked if the resident cannot any longer pay for the costs or care for the pet themselves. Vaccination records and all that have to be produced as well. Or if the employees do not follow the policy, then that can be revoked. We've never had anything other than, I think we have one resident with a cat, and then we have several dogs that are brought into the facility by the employees. But again, performance can't be affected, all of that kind of thing. We recently denied someone because their performance was affected by this pet. So anyway.
I think my performance would be affected. I'm pretty sure I would be like, oh, Joey. Yeah.
So this is really interesting because we're getting ready to become a skilled nursing along with our
Right.
ICF. But several years ago, we had a program where people could bring the dogs and went kind of through the same thing for the clients there. And then we had employees in offices that wanted to bring their dogs in. And then we had employees that said they had an ADA issue because they were allergic to dogs.
Yeah.
And so that just opened up this whole thing to where we don't have dogs at work anymore.
Yeah. And I'll be the first one to admit I did bring Joey in for a half day after our other dog died because I was afraid to leave him at home because he was so depressed. And he sat under my desk. I was like, oh, I could probably do this every day. No one would even know he was here. And he would be one of those dogs that would be okay in Basin. But my other dog would wreak havoc in the Emerson building if I brought him in. So, and I know that it happens occasionally where you find somebody who brings their dog in on the way to the vet, that type of thing. I don't think that's as much of an issue. I think the biggest issue is if you have somebody who needs a service dog and you don't realize it's a service dog, that's what's going to get you in trouble more than anything else.
I think one of the reasons that the state has gone away from actually making that an allowable thing for people to bring their pets all the time is the biggest issue. We tried for a while down in A&I when I first started, and we had an employee who had been bitten by a dog as a child, and she was terrified. And so it brought back some post-traumatic stress for her. And so something that was otherwise a calming and soothing for everyone else, she spent the entire day looking behind her or being nervous to walk anywhere because she thought that dog was going to attack her. And so I think, like you said, with the allergies and the ADA that cropped up, we had the issue of, some post-traumatic stress and some childhood issues with pets that it just really wasn't worth traumatizing employees so someone else could be calm with theirs in their office. So,
And that's why I think you won't see the state adopting any kind of blanket policy that you can bring your dog to work to, there's just too many problems that could come up on a regular basis.
I just have a question regarding service dog certification, because anyone on the internet can go get your dog certified as a service dog.
And that's kind of when you know it's not really accurate because there are no certifications, right?
There's not really a certification process, but what the Department of Justice says is so long as the animal is trained or has a task that is geared towards helping the person's disability, then it's a service dog. So you're going to have dogs that can smell someone's breath to determine whether or not they need insulin. But the most common is going to be a dog for someone with a panic, some sort of a panic issue. And the dog can sense when the employee is going to have some sort of anxiety issue, and then there are things that the dog can do to help alleviate. But so long as they're trained to be able to do that, it's okay.
And the most important thing is to call your AG and make sure.
Yes, it's a part of the ADA process, yes.
Not at all the direction I thought this conversation would go. I thought we would have all kinds of, discipline questions. But. Over here, Jenny. Stacy, behind you.
Is there a definitive list of protected class? Like, is it gender, age? I mean, I just wondered if there was an actual list, or does it get gray and fuzzy?
I don't think it gets gray and fuzzy. If you read the statute in the Civil Rights Act, it lists, and I'm sure I'll miss one, but it's gender, it's religion, it's race, it's national origin, and there's probably a few others in there that I don't recall off the top of my head. And then, being covered by the Americans with Disabilities Act would also put you into a protected class. And then if you're over the age of 40, you are in a protected class because of your age, pursuant to the Age Discrimination and Employment Act.
Liz, would you be able to talk a little bit about lesbian, gay, all that with relation to Wyoming? Is that a protected class?
Being LGBT is not necessarily a protected class. However, because your gender is protected, there are many ways that members of that community are protected. The biggest one is stereotypes based upon gender. We know that that's protected by the law. So you can't discriminate against somebody because of your own stereotypes based upon gender. Obviously, this is an issue that's being litigated a lot. There are many cases where you're going to have someone in the transgender situation where they're going to want to go through a transition, and if someone discriminates against them because of their own stereotypes, they will be protected.
Just a follow-up question to what Tricia asked then, if you have an employee that would be going through that transgender and maybe going through possibly a sex change or something, are you required to provide like a bathroom that would be either or that would be okay as long as it had a lock, or how would you handle that in the workplace?
I will say that I think the bathroom issue is always, I don't know if I want to say it's difficult, but it's different. I think you just have to talk with the person about what they're comfortable with, and then see what you as a facility may be able to do.
Would it be okay as a facility if we had restrooms that were designated as male and female, but we also had restrooms that was designated, either or?
Yeah.
So we could have both kinds and it would be okay with meeting everything, right?
Yes.
Okay, thanks.
Last one, I promise. So I think this is again geared towards Liz, but Liz, can you talk a little bit about your internal procedure or your thought process when it comes to determining the appropriate level of discipline? There are instances where, of course, you don't necessarily have to follow the progressive discipline, but so again, you might jump certain layers or levels. I just was curious what kind of your internal thought process was and what you're looking at.
What my thought process is the rules say that agencies should follow progressive discipline. But then it says, unless the behavior is serious. There's also a part of the rules that says that the level of discipline is solely up to the agency head. So the rule itself, I think, has a lot of flexibility for the agency head. We just had a case in front of the Supreme Court, not on the current rules, but on a set of rules immediately before the ones that we have right now. And the justices seemed a little leery, but we should have a decision in the next couple of months. But generally speaking, I think that like work performance issues are almost never serious issues. And those are the types of issues that the rules want agencies to try to help employees work through. The serious issues are safety issues. I'm sure Brenda could come up with a variety of things that people can do in a correctional facility that are so dangerous that you really feel like you have no choice other than to fire them. So it's really the behavior, but work performance is almost never it. Sometimes, though, someone's work performance is that they're just not doing anything, and then you find out months after that because they just hadn't sheer neglect of almost anything, that may rise to a level of seriousness based upon what the effect of that neglect is on other people in the agency.
I think that's a really good way to look at it, is the work performance is following progressive discipline. I think that's a good way to look at it. Stealing, things like that, I mean, I would assume that the AG's office would look at that a little differently.
Yes, and it's one of those things that I think too, you don't want to kind of pile on at the end. If it's behavior that you've been aware of and it's been going on for a period of time and you haven't done anything, it's unlikely that it's serious. The serious behavior is going to be something that you really didn't know was going on. And then when you found out, you determined that it was so serious that the person should be dismissed.
And that's one of the things that I think that it's not necessarily HR, because I think HR is going to the supervisor and saying, well, the supervisor throws all this stuff on the desk and says, they've been just a nightmare for the last 3 years, I want to fire them. Well, you needed to do this 3 years ago. You needed to start out. We probably could have got rid of the person two years ago if you would have started properly. And I think that's the biggest issue, and I think HR knows that. It's the supervisors sometimes that don't realize that they should be starting right away. Stacy?
I have a question kind of regarding performance again, like Jared. So I'll throw a little bit of mud in there too. So intermittent FMLA and performance. So a lot of times when someone has intermittent FMLA, it's going to lead to some performance deficiencies. And I've had multiple experiences where you have those performance deficiencies and our supervisors are afraid to address it because of the protection under the FMLA. So probably most directed to Liz and maybe even Tricia as well. Do you guys have any recommendations for us on advice we can provide to supervisors to kind of address those issues and keep those things somewhat separate?
Sometimes it's going to be really hard to know if, because the person isn't in the office, let's say 2 hours a day or 1 day every week, if that's why maybe not enough work is getting done, but more work performance issues like making errors, that type of thing, are probably not likely related to the intermittent leave. And, you know, some agencies or some jobs, you can just kind of look at the output to kind of know maybe how someone's doing. If that's a situation, you're going to have to be pretty careful. You know, you're probably maybe going to have to come up with new metrics or a new way to kind of decide, you know, what it is that means that this person is doing enough work when they are at work.
I think intermittent FMLA causes more of the red flags than probably anything else. All right, well, thank you for coming. I think this was